there's data everywhere. We don't know what it is. One of the questions I always ask is, how much data do you have? Do you say grace over to whoever the person is, and they scratch their chin for a moment and say, I have no idea. Say, right, the fair answer. Now, based on that data that you have no idea how much of it you have, how much of that would be regulated or defined as sensitive data? And the answer is, I don't know. And that brings us into the legal maze of the liability that brings with us. Scott.
That is a fabulous segue, and the answer is, with respect to how much of it is sensitive, lots and lots and lots, and that's a legal term if you ever heard one. So before I dive into this, though, I really want to talk about a little bit about the history of data privacy laws going back 50 years, because that's when all this really happened and really started. And what was very interesting is that it plodded along from the late 1970s, actually the early 1970s, all the way to 2013. So you think about all the laws that we're so familiar with nowadays, like HIPAA and GLBA, those happened in that 25-year-ish period after the very first privacy law that came down, the Privacy Act of 1974. So they came along slowly and very deliberately after the Snowden revelations happened in 2013. And just to recap, Snowden was a contractor for the NSA, revealed all kinds of things that were improper, that were being done with personal data and with just looking at data, personal or otherwise. And so those revelations supercharged the legislation that followed, including GDPR, which probably occupies a good chunk of your day. If you're interested in being on this webcast in general, you're probably spending some time on GDPR. So we had GDPR rollout, and then we had the CCPA rollout right after GDPR went live. CCPA was passed, and then we had others that came about. And really what's important is that GDPR model, which was supercharged by Snowden, really then became a model for everything else that followed. So for laws outside, like the LGPD in Brazil, but also here in the US, the CPRA, which updated CCPA and added additional classes of sensitive information. How about that? And also talked about what you could and could not do with that. So it was really an interesting dynamic of how this all developed. And here we are today. This chart doesn't cover all the privacy laws we have. We've probably added another 15 or so since I developed this. But really what's important is that they all typically are based on CCPA or something very close to that. So with that as a backdrop, let's talk about some threshold questions. So I just worked with a client on their posture, if you will, for data protection. And these are the questions that I ask. And this is the questions that I asked of a lot of their employees when I was interviewing them. What kind of data do you have? It doesn't take much to be considered sensitive, and sensitive, not just sensitive in the sense that it's personally sensitive, but it can be sensitive from a corporate standpoint. And I'll talk about that on the next slide. How much do you have? So the old saying about quantity has a quality on its own. Think about geolocation data, because that's a very hot topic right now. A week's worth of your geolocation data, which incidentally will come from your phone, is something that would tell all kinds of things about you. It's remarkable, quite frankly, of what you can be, what can be exposed by just looking at your geolocation data. And I study this with regularity because clients ask about what are our limits, what we can do with geolocation data. So it's truly, truly amazing. Where it's located within your information ecosystem. So there's this idea that there's a lot of data in your ecosystem that you're just not aware of. And in fact, the annual Verizon reports on breaches and breach notification and what have you, years ago talked about this idea that about a third of the data that's stolen from victims of breaches is data that the victim didn't even know they had on their own network. So the idea of where something is located within your ecosystem is so crucial, because unfortunately the bad guys are very adept at finding things that you perhaps were not necessarily looking for. Other point is what's being done with it. So one of the interesting items on CPRA is that for its definition of sensitive data, it's not just the sensitive data, it's also any inferences that are being made from it. Fascinating studies done on accelerometers, so things that are in your cell phone right now. The things that can be inferred from an accelerometer. And I'm going to read from this because it's remarkable. Health condition, body features, whatever that is, gender, age, personality traits, and emotional state, which goes back to what you were saying earlier, Kevin. So this idea is that's from an accelerometer in your phone. Okay, and that's not the only study. I've read other ones as well that confirm that. It's remarkable what inferences can do. So that's important to understand. And then finally, who has access both inside and outside your organization? I think you're probably all familiar with the whole Cambridge Analytica scandal and Facebook. Facebook suspected that they were up to no good, and they interviewed them, but Cambridge Analytica just said, "Oh no, we're okay. We're not doing anything wrong." And of course, Facebook found out the hard way that they were doing bad things. So it's really a question of who has access both inside and outside your organization, and what are they doing with that data. So our next slide. So I'm not going to go through all of these, but some of these are just very interesting in the context of what qualifies as sensitive, because it's not just, again, personally sensitive, it can be sensitive vis-a-vis the corporation. So we're all familiar with personal data. We've talked a lot about that. What's interesting is here in Washington, where I live, we have what's called My Health, My Data. It's ostensibly applies to healthcare data, but the reality is that they've expanded that definition so widely that it's almost a general data protection law. And what's interesting is that what's considered sensitive is geolocation data. Again, we keep coming back to that. It's a very, very hot topic. And there's a private right of action, meaning that if your rights are violated, you can hire an attorney and go after the offender. So it really opens up a lot of opportunity for litigation. You're familiar almost certainly with things like GLBA and all those financial laws. What's interesting about PCI DSS is that it's not just your environment that you have to worry about. With PCI DSS 4, it's any environment that can impact the security of your cardholder data environment. So it's really interesting the scope creep that we see with these laws and why it makes data that perhaps we consider just regular data, if you will, it creates a certain degree of sensitivity towards it. On CMMC, which is those of you that are defense contractors in this call, well-versed probably already with controlled unclassified information and all the things that can go wrong with it. And in fact, my colleague will talk a little bit more about when things do go wrong vis-a-vis the FCA and what have you. But that's all stemming from organizations' inability to properly protect controlled unclassified information. And so all of these different laws that are implicated here, again, I want to emphasize it's not just traditional personal information. It's all kinds of other information that you would likely consider to be sensitive, even if it's not personally so. Event data, like logging data, super important for breach notification, because to be able to unwind what happened to an organization is critical. A lot of organizations don't even keep logs because logging can become very cumbersome, but it's an art or a science that's so important to master simply because of all the breach notification requirements. And for AI, I know Kevin mentioned AI a lot prior to this. And what's interesting about AI is that when personal data gets baked in to a model, as Kevin alluded to, once it's personal data is in, you can't get it out. You can't unbake the cake. And that's a big challenge because then you have to account for that. Under the new Colorado law that's coming up beginning of next year, you have to be able to have full transparency of what's going on with personal data that you've trained on. And that's a big burden, and I don't think companies are ready for it. So just some examples. Let's continue.
So Scott, just a comment on that as you're continuing.
Sure.
One of the things to make that easy, I think, when I explain that to board level folks, explaining what prompting out means, to make it simple, it's just another vector for data loss. So for the data protection professionals on the phone, now I can take it out on a thumb drive, I can go ahead and email it out. Now I can prompt it out. It's another vector for data loss. And that data loss happens inside the LLM, which is the data that you feed based into it. Prompt is the exit mechanism or the egress, understanding what can possibly be egress, the protections around it. So it's another vector for data loss that needs to be protected in different ways.
Absolutely. And in fact, there are new standards coming online, hopefully this summer, simply to address prompt injection, which is what you're talking about, the idea of putting in a prompt to trick the system to coughing up personal information. And unfortunately, it's fairly easy to do. So yeah, great point. in terms of the question, what do you mean by sensitive? I drew this from the California Privacy Rights Act. So this is what's considered to be sensitive. And I highlighted a couple things because we're seeing a pattern here. I've been talking about precise geolocation information a lot. We all know that's sensitive. What's interesting here is that a consumer's mail, presumably their snail mail, their email, text messages, all considered now sensitive information. That's not something that even the GDPR does. So I think it's very interesting that that was considered sensitive because now that mandates additional controls to make sure that's being protected. You have this idea that of neural data. So this is remarkable to me, at least, that now neural information about your nervous system, which evidently didn't fall neatly into healthcare information for whatever reason, has now been called out separately. What is neural data? Great question. I don't know. I don't think the legislature knew, quite frankly, but it's another example of how we have scope creep here in terms of what's considered sensitive. In this case, it's personally sensitive, but the idea of scope creep, I think we're seeing through all the categories I just showed you. Let's continue and talk about some challenges that we're having. So a couple things. One is that there's this idea of accounting for AI. So training on personal information. I mentioned the Colorado law here. In California, we have this coming online as well at the beginning of next year, AB 2013, which you have to disclose personal information that you've trained your AI on. And so it now raises the question, okay, do you track where that information is? What do you consider to be personal information? So all of that has to be thought out before the AI gets trained. My guess is that a lot of these were trained and there was really no attention paid to what kind of personal data got sucked up into that. Also, transparency on contractual levels. So this is something that I deal with every day, where counterparties say, I want to train on all of your client's data. My client says, no, you're not going to train on anything. And then the battle continues. And this is every single contract now has this battle that you're going to train on this, or no, you're not going to train on that. And if you do, we're going to punish you. And we have this dynamic going on constantly. It will never end, unfortunately. Policing your business partners has now become a big issue. So the Healthline case that just came down, I think a week or two ago. So you're probably all familiar with Healthline. They have articles on all things health. Well, what was interesting is that because they're subject to CPRA, there are requirements when they work with advertisers of the data that they're sharing with those advertisers. The advertisers have to follow those rules. And in this case, evidently, Healthline was not policing their advertising partners. There was no in place any kind of a standardized stipulation saying this is how partners are going to be handling personal data. That's a violation of CPRA, and Healthline got fined a little over $1.5 million. So it was a big deal. The equivalent of that is in CMMC. So those of you in the defense sector, the idea, the one thing you never want to hear that you hear all the time are flow downs. The idea that someone upstream from you in your supply chain is making you do all kinds of things that you're likely not prepared to do, including protect and identify what qualifies as CUI. This is something I did years ago working for clients where I spent all my time just looking for the CUI that had to be identified, had to be protected, because downstream, when they were sending the information, if they didn't identify it and the downstream partner didn't protect it, then the onus was on them to justify that. That's the kind of thing that will create FCA, False Claims Act problems for partners. So finally, the EU data alphabet soup. So these are all laws that either have gone live or are going live, and they all have some aspect to sensitive data. It doesn't have to be personal data. It could be any kind of data. For example, DORA, which is really, think about financial data and financial institutions. That's a super law, if you will, that just covers those. So this is something that everyone that works in the EU or has any kind of relationship with partners in the EU is going to have to either comply with directly or indirectly. And I think we have one more slide in this, Tony, if not mistaken. And yes, it's right there. So why your data inventory is crucial. So just finished a project, data inventory with a client, and I learned more about the client through the data inventory than I did through all the other prior interviews that I did. So it's remarkable because the data inventory really serves as your single source of truth. Okay, you find all kinds of things that you probably wouldn't have found before when you develop data inventory with a client. It's your foundation for all your data maps, DPIAs, all those kind of things that are derivative of that. Very important, especially for DPIAs. In fact, probably a third of your DPIA is done just by developing a really well done data inventory. And then also in the first place, DPO is going to check if something bad happens, if there's a breach or there's a suspicion that something's gone wrong. They're going to pull up the data inventory and cross-reference that to what server it is and who had access to it and what are the legal protections it's supposed to have. So very quickly they can get up to speed on what they're dealing with. And then finally, developing a data inventory, every single time you find all kinds of surprises. Data that you thought or the client thought was deleted is in fact not deleted. Some of the data is still being used. Some of it was on a server that no one touched after someone running a project left, and it's still floating around there to be found by bad guys. So long story short, it's amazing the surprises you're going to find when you do a data inventory. One of the reasons why it has to be done.